Feels like they're earning that paycheck.
No.
I know I feel like that.
Had 2 IEP meetings last week with Monday and Tuesday class, then 2 IEP meetings Wednesday and Thursday. So that made, and then CPR Mara and I got to take on, no, excuse me, Mara already took hers, but the rest of us took it on Friday. So that was a really fun week.
Okay. Were they just like initial IEP meetings or just annual reviews or
Annual reviews, yeah.
Okay.
I had to give my first one, so by myself. So
How'd it go?
I think it was okay.
You didn't break any laws, did you?
I'm hoping not.
I'm sure you didn't.
But that's what's in the back of your head the whole time now we're taking these law classes.
Right?
Right, yeah. You're just trying to think back to, because there's a lot to these laws. I mean, a lot of like small potential loopholes. There's room for interpretation, even though there are many areas in which the IDEA does explicitly state, statutes or not statutes, but regulations. They're still open to interpretation. And I'm assuming that you all get that, or you all know that. Having done reading about all these different court cases that, courts judge one way in one state and they make opposite decisions in other states. And so it can be a challenging terrain to navigate. Okay. Any questions or anything before we get started? Observations, thoughts? Okay. Well, then let us dive right into another exciting installment of the legal and procedural aspects of special education, wherein today we will be discussing parent and student rights and discipline to the IDEA. Okie dokie. So we'll go ahead and start with chapter 4, and that's the one that covered parent and student rights. Most of the focus with regards to parental rights was on such items as, notification of changes in placement, notification of changes to IEPs, etc. Whereas most of the student rights portions were based on the protection of sensitive information. So they discussed a lot about FERPA in the chapter, which is an important agency to be aware of and to be familiar with, especially working in this field where we do have access to very sensitive types of information that we don't want to be exploited.
There's teachers in my building right now that are asking for an entire spreadsheet of all of the SPED students in the whole building.
So teachers want information about all of the SPED students in the whole building, in the whole school, and they're not those students' teachers?
That's correct. Because they say that they need that information for hallway interactions. Yeah, and I explained to them that they can find information about students that they have on, on the Synergy website. I don't know if everybody uses Synergy, but on like the attendance website, they can find the information about students. And if they don't have them, then they don't have them.
I mean, there is one exception to those FERPA. I mean, the book lists like those 11 exceptions to FERPA's rules governing like who legally can have access to like educational information.
Yeah, I saw that.
Right, and so were one of those teachers going to have one of these students in their classroom the next year? Well, then make an argument for it being a valid request for this information. But just to inform hallway interactions, I think does not qualify them access.
Yeah, there's been a big fight about it in my building. Like my building's pretty interesting. Anyway, it's just been like this constant fight with these teachers.
Interesting. So they maybe their argument is that, well, we want to know which kids have, disabilities so that, like, if a kid gives us a certain reaction or something, like, we know that maybe this is just a manifestation of the disability. This is not like a kid who's just like being contentious or trying to argue with us or something.
Right.
Yeah.
Right.
Yeah, that's tough. Yeah, unfortunately, I mean, I don't think they're legally obligated to that information.
That was my inkling, but
Yeah.
they think that they are older and wiser.
When all else fails, just play it as safe as possible when it comes to this type of stuff, you know?
Yeah.
Okay. So we're all familiar with the fact that a big part of IDEA is to put into law, basically, safeguards and such that are designed and intended to make parents equal partners in the development of their child's educational programs, or their children's educational programs, specifically if those children or that child has a disability. And so, IDEA builds into its comprehensive set of regulations certain safeguards that require school districts to do certain things in order that parents are having the appropriate opportunities to be active members in the development of these programs. Additionally, we've learned that the IDEA also has in place a number of safeguards that protect parents against, school districts or school officials who, try to pull the wool over their eyes, so to speak, with respect to things like making, changes in placement or substantial changes to IEP goals and stuff like that. Just to take the language specifically from the IDEA, basically these safeguards are designed to provide parents with the opportunity to examine all records relating to such a child and to participate in meetings with respect to the identification, evaluation, and educational placement of said child, and the provision of a free, appropriate public education to such a child. And if required or requested, to obtain an independent educational evaluation of the child. So to make a long story short, this is just IDEA's way of ensuring that parents have every opportunity to be involved in every stage of the special education, process, or call it the system. Of course, parents have the right to waive these rights, but as we'll talk about a little later in the presentation, there are certain situations wherein if a parent does waive these rights, like for example to attend IEP meetings, well, they also kind of waive away some of their other rights related to making changes to an IEP. So really the safe course of action here is for parents to be involved to the maximum extent possible. Not a realistic outcome for many parents, because we all have to work and we're all busy. But certainly, there should be an effort made by you as special education teachers and other special educator, practitioners to encourage parents to be involved. And so the IDEA defines the term parent in a number of different ways. So it doesn't just limit it to the natural parent. It could be an adoptive parent or a foster parent of a child, unless there's a state law that prevents a foster parent from serving as a parent in this type of situation. Just a guardian. The state cannot be a parent in IDEA's eyes if that student or that child is a ward of the state. An extended family member could be considered a parent, grandparents, step-parents, or other relatives. If this, if this extended family member is the individual with whom the child lives, or if this extended family member is legally responsible for the child's welfare. And then again, as with all aspects of IDEA and how it is interpreted, state laws can further refine or place additional restrictions on, in this case, who may be considered a parent. But as we've also seen, state laws and interpretation of IDEA can also vary from state to state. So it's not just in terms of how IDEA defines the idea of a parent. So again, I've already alluded to this. Congress in enacting the IDEA has placed and recognized the importance of placing importance on parental participation. Our students will not make the educational advancements without parental participation that they would in a situation where parents were actively participating in their child's educational development. And so really, case law really makes it clear that school officials must offer parents opportunities to participate meaningfully in the development of IEPs for their children. And again, not just in the IEP development, but at all stages of the special education procedure, from identification onward. And so again, we've talked a lot about due process rights with respect to students that benefit the children, so to speak. The Supreme Court has also ruled on a number of cases with respect to the rights that parents have kind of on their own, independent of the rights granted their children, provided by the IDEA. And so one is parental notification. Does anyone remember what this regulation refers to? Notification of what?
Of any changes, IEP reevaluation.
Yeah, that's definitely one of them.
Anything that
any kind of changes are going to take place in the context of their child's educational plan, well, parents need to be notified. But there's a broader focus of this regulation. And it doesn't have anything to do with the student. Once per year, IDEA requires that parents be fully informed of their rights. Not only to be informed of changes to their child's educational placement or educational program, but they also must be informed fully of their rights once per year. So they should get something in the mail or an email, or the means of transmitting this information will be individualized based on however is most convenient for the parent. Obviously, if an individual does not have an email account, we wouldn't say, oh well, we tried to send mom and dad they don't have email, so we weren't able to fully notify them of their rights this year. That would be a very clear violation of this right.
I usually just hand out a packet at the IEP meeting.
Yeah, that's what we do too.
Yeah.
Right. So you got them there,
And we
face
have
to face, just give them the hard copy. That's an
We
excellent.
have them in multiple languages in our district.
Right. But what about cases in which a parent is not able to attend an IEP? Would you just put it in the mail or send it?
Yeah.
Yeah.
Mm-hmm.
Probably wouldn't send it home with a student. That doesn't seem like a very serious. It might come home missing a few pages.
Crumpled in the bottom of a backpack.
Again, education officials must notify parents of initial referrals or even the first request for an evaluation of their child. On the first occurrence when they file IDEA-related complaints and when they make such requests. So basically, yes, this is just saying that in addition to them fully informed of their rights once per year, when there is, conjecture as to whether or not, or there's speculation that a child might be requiring special education, well, parents need to be notified before any steps are taken toward the end of putting that whole process into motion. And again, parents have the right to say, you know what, we don't want our child in special education. We don't want you to evaluate our child. And they have that right. And again, the purpose of parental notification is just to provide parents with sufficient information to protect their rights, allow them to make informed judgments, and to fully participate in due process hearings if necessary. So this is just essentially, a way of IDEA providing school officials, school districts, a means by which to protect themselves from finding themselves in lawsuits or, being involved in cases in which they made, significant changes to an educational program or replacement, or, instituted some form of discipline, and parents were not, made privy to that change or to the implementation of that disciplinary action. So again, there are IDEA outlined 7 key elements that parental notice must contain. If a school official or district is refusing to take an action or is requesting that an action be initiated, well, that action needs to be described in the parental notification. There needs to be an explanation for why the proposed act or the refusal to propose some act or to propose some change, why they've arrived at this decision. Describe all of the pieces of information that these school officials are using as the basis for, proposing take an action or refusing to take an action. So any assessments or evaluations that were conducted that inform these decisions, any other type of procedures that might have been conducted, or records that were used as supporting pieces of evidence. Well, these all need to be explicitly outlined in this form of parental notification. And again, just a general reminder to parents that they retain procedural safeguards along with information about where they can go to obtain descriptions of those safeguards. School districts must identify sources that parents can use in the case that they are having difficulties or experiencing challenges understanding the contents of one of these notices. This could be a lawyer's contact information or a special education advocate's contact information. I think it varies from district to district, kind of with respect to who this source of information or what organization would be this source of information. If a school district or school personnel are considering like a change in placement, for example, well, this notification needs to describe the other options or the other steps that were taken prior to suggesting that this change of placement in this hypothetical example was made. So, they would need to say, for example, they might need to kind of walk through the different kinds of accommodations that were implemented in the classroom and, how those were unsuccessful. They might need to articulate, specific instructional, strategies that were ineffective. In short, school officials or school districts kind of bear the burden of proof, especially in these situations in which, they are the parties who are requesting an action to make a change in placement. Lastly, it needs to be in language that is, not full of jargon or too technical. It needs to be generally understandable, or understandable to the general public, excuse me. It needs to be available in a parent's native language. If a copy of this notice in a parent's native language is not, possible to generate, well, then school officials need to make sure that the notice is translated orally or by some other means or mode of communication in a way that parents are able to understand it. And there also needs to be written evidence that educators satisfy these requirements. So I'd imagine that there would need to be, like a signature page or something signed by a parent indicating that they did indeed receive such a notice. Another parental right that is separate from a student's rights as offered by the IDEA is parental consent. So basically, school boards must obtain informed consent from parents before any evaluations can be conducted to determine if a child, might be eligible for special education services, and also prior to providing any special education services or related services. I'm assuming that at all of your IEP meetings, at the conclusion of these meetings, that there's a signature page where everyone signs off in agreement on the contents of the IEP. Is that correct?
Yes.
Yeah. So that's just an example of parental consent in regards to this last point that I mentioned here.
Can I ask a question though?
Yeah.
So on the other page, it talked about that in Louisiana that that they did not grant parents veto power. But when you're sitting at the IEP meetings and the parents are asked if they agree or disagree or those things, they do have the power to say, we're not okay with this, this is not what we want. Or after your initial testing, parents can say, we don't want our kids to have an IEP, right?
Right.
So wouldn't that give them the veto power then?
So you brought up as an example a case from Louisiana. Is that what you had said, Colby?
Yeah.
What page was that on? Do you have your book in front of you?
Yeah, 96.
I'm just curious.
Above where it says parental rights, there's a paragraph, and then it's the line right above that. It has a little 8.
The Sixth Circuit affirmed the relevant part of an earlier order, finding that educators in Tennessee violated the rights of a child and its parents. Sorry. However, in a case from Louisiana, the Fifth Circuit clarified that the right to provide meaningful input does not grant parents veto power over the decisions of IEP teams or the right to dictate outcomes. That's a good point. So basically what that is saying is that in this case, it sounds like a parent was trying to kind of unilaterally veto some IEP goal or something, or some decision reached by the collective IEP team. And
But don't they have that power? They can say, I don't want this, or I don't agree with this, or...
Based on my understanding of the law, absolutely. A parent has the right to say that. And if they say that, well then, whether it's the entire IEP or it's some, kind of smaller section or component of the IEP, well, then it can't be implemented. So the case would need to be brought before a hearing officer, right? The hearing officer is like the person in between you would go to prior to bringing it to the court system. If a hearing officer can't, make a decision, or can't, help the parties reach an agreement, or even if the hearing officer does help those parties reach an agreement, but the parents or the school district don't agree, well, then the next step would be to go to court. So, yeah, I mean, this does clearly seem to contradict this idea But I do know that parents do have the rights to not agree with an IEP or any component, any section thereof. So in this case, if parents refuse to or otherwise fail to provide consent for evaluations of their children, so now we're talking about evaluations, and school officials believe that these are warranted, well, they may also use IDEA's due process hearing mechanism to seek to override the lack of parental consent, unless doing so is inconsistent with state law. So in this case in Louisiana, it sounds like that's what happened. Parents tried to kind of like unilaterally dictate like an IEP goal or something, right? Because they talked about the right to dictate outcomes. And it looks like this case went all the way to the courts, and the court said, no, parents, sorry, you can't do that. You can't, you in and of yourself, or you and your husband or wife, do not possess the expertise necessary to unilaterally just say, well, this is what we want our son's IEP goal to be, or this is what we want our son's IEP to focus on. And so it sounds like this is a case in which that was brought all the way to the courts. So IDEA does not allow boards to seek overrides of parents' refusals for services, including circumstances when they choose to homeschool their children rather than submit to their services. So if a parent says, we don't want our student in special education, we're going to pull them out of the school district and homeschool them, well, now IDEA does not have any say in that matter, right? Because as somebody providing homeschooling, you're not receiving federal funding in support of that homeschooling effort. And so this is an area in which the IDEA would not be able to, in which it would not be kind of valid law, basically. So let's just look at some of the effects of procedural errors. So those cases in which school officials do indeed violate kind of the letter of the law, so to speak. So in those cases in which maybe the letter of the law, like the law wasn't followed to the T, but the error that was produced in not following the law to the T does not interfere with parental participation in the IEP process. According to the textbook, courts generally do not invalidate IEPs. It was a small oversight, and there was nothing like, no major new outcomes were developed and accepted, and in those cases, chances are it's not going to be too big of a deal, provided that the IEP is still appropriate for the student and kind of not changing that student's program or placement in any major way. If the violations prevent active parental participation, so if parents aren't notified of an IEP, for example, well, these are errors that are generally large enough to have IEPs invalidated in the eyes of the courts. So as long as a small procedural error does not prevent a parent from participating in an IEP, well, chances are that things are going to be okay, and you're not opening yourself up or your school district up into any legal ramifications. And again, just any kind of explicit or clear violation or disregard for these basic provisions that are provided in the IDEA provides courts with ample evidence to use in the process of invalidating a proposed IEP, especially if it's this situation in which there's been some action on the part of a school district that has prevented parents from participating in their child's IEP. And again, we are all familiar with this description of an IEP meeting. They're conferences that provide parents with the best opportunity to participate in the development of appropriate educational programs for their children. It's an opportunity for team members to review evaluation results, develop IEPs, and also to make placement decisions. So again, as an initial matter, it is critical that school officials or whoever's in charge of scheduling these IEPs take steps necessary to ensure that at least one of a student's parents is present at IEP conferences. And again, a parent does not have to attend, that's their right, but there needs to be efforts taken, and these efforts need to be documented. It would need to be proved that, parents were, actively kind of pursued and were attempted to be contacted to participate in an IEP meeting. Not only that, but parents need to understand what is happening at an IEP meeting. So in the case of parents who speak English as a second language, well, obviously there would need to be a translator provided in that situation in order for this type of parent, in order for this type of parent to understand fully what is taking place. A student in one of my other classes has a parent whose child has an intellectual delay, and the parent also has an intellectual delay, or an intellectual disability, excuse me. And so this parent actually has an advocate that comes to the meetings with her and kind of interprets the language that's being used in the IEP meeting, so that she has a better chance of comprehending what exactly is taking place and what decisions are being made. And again, I mentioned this, by failing to be present at IEPs, parents may give up some of their rights, and the textbook does provide a few examples of cases in which this occurred. Regarding IEP revisions, again, it is always necessary to alter an IEP, maybe not annually, but at least triennially. Triennially, excuse me, triennially. It's a fun word to say. Again, very minor adjustments not resulting in changes in student placements might be of little consequence. But in those cases where a change to an IEP is going to substantially alter that IEP, or result that an IEP not be implemented as previously written, in this case, IDEA procedural safeguards would be triggered. So it might be the case that a very slight tweak here or there is not going to be huge if a parent wasn't notified. But in those cases in which major changes are being suggested and then implemented, well, there needs to be this parental notification. But again, I would never advocate for making any changes to an IEP without first notifying parents of the desire or the need to do so, just to not put yourself at risk of getting in trouble. And again, this is nothing new. With respect to these major or substantial alterations of IEPs, parents must be notified, especially if these substantial alterations are in the form of educational changes in educational placement, or if major modifications are being proposed to help a student achieve her or his learning outcomes. Well, parents must be notified of these types of changes as well. But again, the safest bet is just to always notify parents of any change that is going to be made to an IEP goal. And again, if there are no legal reasons to the contrary, IDEA's parental rights apply to parents who do not have custody or non-custodial parents. The non-custodial parent, meaning the one who, in the context of a divorce, does not have custody of the child. But again, there are cases in which courts ruled against just what I'm saying here. There were cases in which, in the textbook lists about 3 or 4 of them, in which a dad who did not have custody of his child attempted to, challenge changes to a student's IEP, and that dad's attempts were shot down by the courts. And so again, this is one of these situations in which it is likely taken on a case-by-case basis, unless there is this really clear court order in place that says that this divorced parent who does not have custody of the child should never be allowed to make any kind of decisions related to the educational outcomes of said child. In those situations in which students reach the age of majority, they turn 18, most of the rights, most of the decision-making power does transfer to that now adult student, but it does not mean that parents automatically lose all their rights just because their child has reached the age of majority. Parents are definitely still entitled to a notice as to what is taking place with regard to the education of their child. Maybe they don't have the power to, be an active decision maker in the process, but they still are required to be noticed, even though it would be the student who would have the power to make such a decision. And again, if a young adult is conserved, if they don't possess the intellectual capacity to make these kinds of decisions, well, in this case, parents or other appropriate individuals will be representing individuals or representing the educational interests of them when they do reach the age of majority or the age of 18. Oh, go ahead.
Does that count? So if they turned 18 at the start of their senior year, does that still play an effect, or is it after they get out of high school?
Oh, if they were 18 during their senior year of high school and they were conserved, like, they didn't have an intellectual disability or any kind of condition so severe that they couldn't make these decisions on their own, well, then they have the full power to sign off on their IEPs. And then, they have the full power to make any educational decisions related to their educational outcomes. I would imagine that if a student just started making some very dramatic changes, that there would probably be some kind of safeguard triggered. But provided that that's not the case, they do hold that power. Any questions on the rights afforded parents by IDEA? Essentially, just to make a long story short, make sure that they're always notified of any kind of change or any kind of meeting that's happening with respect to their child and that child's, educational outcomes. But just the safest approach to take. So again, the book chapter in the section that talks about, rights with respect to students, it talks a lot about student records and privacy. And it talks about the Family Educational Rights and Privacy Act, FERPA. So this was actually put into place 1 year before the first version of the IDEA, which was Public Law 94-142, if I recall correctly. And this, the FERPA Act has basically 2 main goals. Basically to grant access to educational records to students who have reached the age of majority or parents, and also to limit the access of outsiders to those records. And so what kind of records does FERPA cover? Any kind of educational records that contain personally identifiable information. So students' name, social security card, or social security number, race, ethnicity, age, anything that can be used to kind of get a better picture of who this student is would be covered under FERPA. The directory information is something that's a little different than an educational record. Directory information refers to a number of different types of information. This would include names, addresses, telephone numbers, dates and places of birth, participation in officially recognized activities and sports, degrees and awards received. This information can be released to third parties, but before that is possible, parents must be notified, and parents must be given a reasonable amount of time to request that the material not be released without their consent if they if they choose to make that decision. And again, FERPA requires school officials to notify parents of their annual right to inspect and review, request amendment of, and consent disclosure of educational records, as well as to file complaints with the Federal Department of Education alleging failures to comply with the student's dictates. Yeah, just as the IDEA requires that parents be informed annually of their rights, FERPA requires that parents also be informed annually of their rights with respect to the educational records of their children. So the textbook talks about 4 major exceptions to FERPA's classification of educational records. And these include basically records made by like teachers, for example, that are in the sole possession of that said teacher, and that is not accessible by or revealed to other people. Of like, I don't know, a teacher wrote a note to a substitute teacher about a student, and kind of maybe what to expect, in working with the student, or provided the substitute teacher with a strategy for dealing with a particular student's challenging behavior. That would be basically a category of information that is not protected by FERPA. Separate records kept by law enforcement units of educational agencies that are used for their own purposes cannot be accessed by third parties. Records that are made in the ordinary course of events relating to individuals who work at but who do not attend educational institutions. That refer exclusively to their capacity as employees are not available for any other purposes, are not subject to disclosure, and records related to students who are 18 or older, who attend post-secondary educational institutions that are made by physicians or psychiatrists or psychologists or other professionals or paraprofessionals for use in the treatment, are not available to others except at the request of the students, cannot be released. These are just 4 different types, 4 varieties of information that basically are not subject to release. Regarding access rights to educational records, again, absent of court orders or applicable state law, non-custodial parents have the same rights to educational records as custodial parents. Also, a student's age and the type and severity of his disability can be taken into consideration when considering whether or not to grant rights of access to educational records of students 18 and older. So if for some reason it is determined that, given the severity of a student's disability and how it manifests, that it might not be a good idea to grant the student access to his educational records, well, that information can be taken into consideration when making this kind of decision. And then lastly, provided that parents provide consent, third parties generally can access school records or students' educational records. So not just that directory information, but educational records as well. But again, it's only if parents or other, a student who has reached the age of majority provides written consent that that's okay. So the textbook describes 11 major exceptions where permission is not required before officials can review educational records. The school employees with legitimate educational interests. So knowing what students that one might encounter in the hallway have disabilities is probably not a legitimate educational interest. And we talked about it at the beginning with Becca's example. But if you were going to be having a student in your classroom next year and you wanted to have a look at that student's educational records, well, that would be considered a legitimate educational interest. You just want to get, to know a bit more about the students. And in that case, that's something qualitatively different than knowing what students in a hallway, situation might have a disability. As long as parents are notified, if a student applied for, kind of post-secondary program and was requesting access to that student's educational records, that's another situation in which permission would not be required based on FERPA's guidelines. But again, parents would need to be notified. And I think in this situation, if a parent said, you know what, we don't want that, school or institution to have access to these educational records, well, then they would not get to have access to them. But chances are, if a student is applying for a community college or an undergraduate program, that's not going to be the case. Authorized representatives of a number of different agencies are requesting, information about a student for law enforcement purposes. This is another situation in which, permission would not technically be required for these individuals to see a student's educational records. Individuals who are responsible for determining financial aid requirements and need can have access to this type of information. Organizations conducting studies on behalf of educational agencies or institutions developing tests or administering aid programs for improving instruction can have access to educational records, but without personally identifiable information. So no names or social security numbers or unique student IDs or anything like that. Accrediting organizations, especially universities, they need to be accredited. They need to go through a very rigorous accrediting, process. So oftentimes these accrediting organizations will want information about students. And so this is another situation in which, educational records could be provided without permission. Parents of the children can always have access, although they, we discussed earlier that annually, they need to be notified annually of their rights to view and request access to their child's educational records. Emergent situations, people who might be protecting the health and safety of students or other persons. If records are subpoenaed or otherwise sought by judicial orders. Again, another type of situation in which educational records would be allowed without first obtaining kind of the purpose required forms of permissions. In this case, of course, parents must be notified in advance. For the purpose of program monitoring, Caseworkers or other representatives of the child, or or representatives of other specified child welfare agencies who have a right to access case plans for their children and their care can access the education records or the personally identifiable information contained in such records. Chances are, no one here will ever need to have such a close familiarity with FERPA's rules and guidelines. But again, it is good to at least know where to go to, get this kind of information, in case one of your colleagues is curious, or, maybe you are approached by a third party, a representative by a third party who wants information on one of your students. It is good to know, kind of what type of information is protected and who would or would not be allowed to access that information. And again, any third parties seeking disclosure of student records must have written consent from parents or the qualified student in the case the student has reached the age of majority and is not conserved. And this consent must indicate what are the records to be released, what are the reasons for the proposed release, and who is going to get this information, if not just you, third-party individual who is requesting access. So there needs to be a lot of transparency in terms of, specifically what records are being requested, what are the reasons for requesting them, and who else is going to see the information contained in the records. Additionally, school officials need to keep records of all individuals or groups, except for the exempt parties that we just looked at, who request or obtain access to student records. So again, there is a lot of effort put into protecting the privacy and the rights of students with disabilities who are protected by IDEA. In those cases where an educational agency, has been provided with a request to provide student records, they need to grant access within 45 days. So there is a time frame here. It needs to be done in a somewhat timely manner. Amending records, parents can, if a parent or a student is looking at, her or his educational record or their child's educational record, and they don't agree with something in that record, well, they can request an amendment to the disputed information. And if officials refuse to grant requests to amended records within a reasonable time, parents or qualified students are entitled to hearings at which hearing officials evaluate whether the challenged material is accurate and appropriately contained within the disputed educational record. And if it is found that the contested information is inaccurate or misleading, or it otherwise violates the rights of students, or violates their privacy, school officials must amend the contested information accordingly and inform relevant parties once it has been done. So educational records actually can be changed. However, there is a proper channel that must be taken in order to get those records amended. I'm going to go through one more slide and we'll take our break, because after this slide, we're going to shift over to student discipline. The records can be destroyed when they are no longer needed to provide a child with, SPED services or FAPE. So, old IEPs or old test protocols or any other type of, educational record that is no longer necessary for, providing a student with, adequate SPED services, well, that information can be destroyed.
How long should you, what's the best policy for keeping paperwork on students that you don't have anymore? Is there I have business records, I keep them for 6 years or something. Is there a best practices for that kind of thing?
Yeah, I'm sure there is, but off the top of my head, I don't know what they are.
Well, wouldn't those records go to the new school that the students were at?
Right. That's a good point. Unless maybe the student like graduated high school and is going to college and maybe wants access to those records to justify requests for accommodations. So I'd have to look into that because this chapter definitely does not mention a timeline for how long these records should be maintained.
And could that be like state or district? I mean, regulated?
So the regulation adds that parents or qualified students must be advised that records are going to be destroyed and that school officials can save without any time limitation records including students' names, addresses, phone numbers, grades, attendance records, classes attended, and grade levels completed. Okay. Yeah, but it doesn't say like how long they should be kept. But it does say that they can keep them indefinitely.
I think our school has I think it's a 5 to 10 year. I know that there's 2 years out that we have to keep them in one room, and then they get moved somewhere else for another 5 to 7 years, and then the school secretary is calling and asking before they destroy them. That seems like an awful lot of time when it doesn't give you, that must be a district policy, but that still seems really, really long.
Yeah, but I feel that they would always want to err on the side of being too cautious. So keeping them for an amount of time that seems too long as opposed to just like destroying them right after the kid graduates or something.
Right. We have like 3 file cabinets full of them though, from years past. And
Right. Yeah, so yeah, since this textbook is very thorough and it doesn't mention a specific time frame as dictated by the IDEA, I would imagine that it would be, up to the districts with respect to how long these records should be, like after a student graduates, for example. But anyway, I'm going to stop there. Let's meet back here at 6:15. We'll take 10 minutes, okay?
All right.
Hello.
Oh.
Hey. So we'll talk about student discipline next. And I'm curious, any of you been involved or had to deal with suspensions or potential expulsions of students? Any of your students?
Definitely.
Okay, so then not an area that's completely new to you. And so were these, I'm assuming that was Nate who said definitely?
Yeah.
Were these situations, I mean, did you have to sit in on manifestation determinations and all of that?
I've been in one manifestation determination meeting, but most of the time it's like 1 to 2 day suspensions, and then
Which doesn't really trigger the safeguards provided by IDEA.
yeah. Well, until you hit that 10-day, or you start getting close to that 10-day point,
Right.
and it's like if you feel like at 5 days we usually start looking at trying to be proactive at what the protocol is going to be if we if this student is showing it, if he's getting suspended for 2 days every 2 weeks,
Right.
then you're going to get to those 10 days pretty quickly.
Right. So
So
you start thinking about that. Your team starts thinking about strategies. What are you going to do? Okay.
yeah, just like
Anything else been involved in like longer term suspensions or getting up to like that 10-day period? No? Okay. All right. Well, student discipline. As you will recall from the readings, as originally enacted, there wasn't much to be said about student discipline in IDEA. There were some provisions that, from which you could draw, implications that might be applied to situation involving students with disabilities being disciplined. It was really in 1997 when the big piece on student discipline was introduced. And as I mentioned here, it comprised the most comprehensive set of amendments to IDEA, was this discipline section. And in 2004, with the most recent set of amendments, these provisions were also kind of refined and retweaked and then reorganized a little bit based on, the accumulation of court decisions that had kind of amassed in the number of years separating 97 2004. So just looking at the historical overview, we have this case Stewart v. Napi, in which a student was unsuccessfully expelled. The student was involved in school-wide disturbances, and the court ruled that insofar as an expulsion was a change in placement that was inconsistent with IDEA procedures, school officials should have provided her and her parents with written prior notice before attempting to modify her educational placement. An example in which, the student's rights were violated, rights, provided by IDEA, and also the parental notification rights that a parent enjoys thanks to IDEA. This was kind of one of the earliest decisions in which there was an official, opinion laid down by a court regarding the expulsion of a student with disabilities. Doe versus Koger. Again, this is an early case in this that spoke to the importance of a manifestation determination. This was an individual with mild intellectual disabilities. Was trying to expel this student, but they were not allowed to because it was determined that this student's disruptive conduct was caused by her disability. This this became known as the manifestation of disability doctrine. Now we have a manifestation determination meeting. But it was this case that put that thinking into process, or into motion, I should say. Excuse me. And again, this case, this court also provided the opinion that students in special education who are disruptive could be transferred to more restrictive settings, but only if school officials followed the proper change in placement procedures. Of course, as we are well aware of, this includes, exhausting all of the possibilities that are at the school's disposal that might be employed to keep the student at the school successfully, and also notifying the parents of the student's parents of the action to make the change to a more restrictive setting. SI versus Turlington. A student from Florida was expelled for misconduct and requested a manifestation hearing. The superintendent denied it since the student was not classified as emotionally disturbed. In overturning the expulsion, the court found that a manifestation determination must be made by a specialized and knowledgeable group of persons. So here, a single individual was attempting to serve the role of the manifestation determination team. This is an early example of the courts recognizing, well, just because you're a superintendent does not mean that you possess all of the necessary expertise about the student's current life situation, the student's disability, common manifestations of this disability, etc. The court further explained that even with expulsions, school officials could not completely cease serving students with disabilities. And so that regulation still stands today. If a student is expelled, that student is technically still required to receive special education services. In the capacity of a home tutoring program, until a more suitable placement for the student is found, and that student is then placed. Early cases certainly permitted school officials to exclude students with disabilities who pose dangers to themselves and others. Again, as long as proper procedures were followed. So a lot of emphasis here on following proper channels laid out by IDEA, or in this case, excluding students with disabilities, more specifically those who are dangerous to themselves and their peers and our teachers. So there's been one Supreme Court decision, Honing versus Doe, and kind of the Supreme Court's only opinion involving discipline under the IDEA. It involved two students. Doe had a diagnosis of EBD. This individual assaulted a peer and broke a school window, was suspended for 5 days, and then placed on indefinite suspension pending an expulsion hearing. The student's lawyer recognized that this was in violation of the student's rights and asked the school officials to cancel the expulsion hearing and to reconvene a meeting of his IEP team, which is what exactly would be done in the context of a manifestation determination meeting. I mean, essentially that team is the student's IEP team. But the court ignored this lawyer's request, which triggered a judicial review, and then eventually a federal trial court canceling the expulsion hearing, ordering the student to be readmitted back to his school and preventing educators from excluding him while officials sought to place him in an alternative setting. So this is kind of an early decision that informed this idea of an interim alternative placement, which we'll talk about in a few slides down the road. And then Smith was the other student involved in this Honing versus Doe case. Again, a student diagnosed with an EBD, displaying aggressive tendencies, was placed in a SPED program in a regular school on a trial basis, committed a number of acts of misconduct. His program was reduced to half a day. And interestingly, his guardians, who were his grandparents, agreed to the reduction. However, they were not advised of their rights or options regarding his IEP. So while they agreed to it, they were not advised of their rights regarding, this very significant change to the student's placement. The student was then suspended for 5 days after making sexually explicit remarks to a female student. And then again, as in the case of Doe, the expulsion was extended pending resolution of expulsion proceedings. This district seemed a bit more informed than the previous one. When this student's attorney objected, the board officially canceled the expulsion proceedings and offered either to restore the student's half-day program or provide him with home tutoring. In 2 different cases that the Supreme Court gave an opinion on in the context of student with disability discipline. In this case, these opinions informed the regulations provided in the context of IDEA related to moving students to interim placements while decisions are made as to the best decision for a more permanent full-time placement. Again, the litigation initiated by Doe and Smith, or versus Doe, it was agreed that students with disabilities could not be expelled for misbehavior that was related to their disabilities. The court acknowledged that in enacting the IDEA, Congress intended to limit the authority of school officials to exclude students with disabilities, even for disciplinary purposes. Again, this is where we get the of a 10-day period of suspension, during which, an IEP team is or should be, seeking to reach some form of agreement with respect to alternative placements for the child. If it's clear that, these suspensions are persistent and happening very frequently, well, it's very clear that, A, there might need to be a new placement, or B, maybe there's something, faulty with the IEP, which we'll talk about. The Supreme Court also added that, teachers, other school officials could impose normal non-placement changing procedures in the context of a classroom. So things like detentions, timeouts, restriction of privileges, are all okay responses in the provision of student discipline because, they are non-placement changing. Unless, of course, a student was getting a timeout every single day, for the entire duration of, the time that student was at school every day. Well, if a student spending that much time in timeout, well, then I think the argument could be made that this is in effect a change in placement, because the child is completely missing out on the learning opportunities in the classroom. So this Honing gave school officials the ability to seek injunctions to remove students with disabilities who are dangerous or who create serious disruptions to the educational process while administrative and judicial proceedings are pending. So that was kind of one of the big takeaways here, that it was okay to take a student out of a situation, that an educational placement that is inappropriate, to protect that student's health and the health of that student's peers and the safety of that student's peers and the student's safety, while decisions are being made as to kind of, what to do next. In these situations, the burden is always on the school to demonstrate that students are truly dangerous and that the removal from their then current educational placements is the only feasible option. So the then current educational placement, does anyone remember what that term refers to? The then current placement. It's the placement
Where they're currently placed.
exactly the placement in which the student is placed when the misconduct occurred. And again, the burden is on the school district to show that they have taken every reasonable measure to mitigate the dangers such students pose to themselves and others, if placements can be granted. So it's not just enough to say this student poses a threat or a risk, a safety risk to her, to herself and her peers. That's not enough. There needs to be evidence of the efforts taken by the school district or the teacher once that realization was made. The efforts that they took to kind of work with the student to mitigate those challenges and to keep that student in the classroom. Other issues emerged from this, like the litigation that occurred after this honing case, and that was one of them was in regards to discipline of students who were not yet identified as students with disabilities, and whether or not they were entitled to the IED's protections. If indeed these students claim to be eligible for special education. So this is an interesting wrinkle in the landscape. Generally speaking, the IDE's procedural safeguards must be applied regardless of whether a student has been previously diagnosed as having a disability, if there is reason to suspect that the student might have a disability. So if there is written documentation from like a parent who is concerned that their child, might be falling behind in school because of, an undiagnosed disability, or if there are, some kind of evaluation or assessment results that suggest that a student, might have a disability, or if, there's written documentation, or if there's written evidence documenting a teacher's concern for a student as possibly having a disability, well, this is all evidence that could be used in favor of, a student's entitlement to IDE's protections, even if that student is not officially provided SPED services under IDEA. So an interesting wrinkle in the situation. Another issue that this litigation brought up is, well, what about students who are formerly in special education and who are not currently receiving services when they committed their disciplinary infractions? Are they entitled to the IDEA's protections? And I guess that depends. There's one case that the book talks about in which the student's mom pulled him out of his special education program. Well, in that situation, the fact that the student's mom just pulled him out of SPED did not change his status as being in need of special education, and so he was entitled to IDEA's protections. The book doesn't talk about like cases in which maybe a student no longer qualifies for special education because the student loses her or his diagnosis, which is possible with some disabilities. We definitely hear about kids with having been diagnosed with autism spectrum disorders, kind of years down the road, losing that diagnosis. And so I'm not clear on what would be the precedent in that regard. Another issue is how school officials should treat students who are evaluated but not classified as having disabilities. according to the textbook in general, it is suggested that educators employ a flexible approach when applying the IDEA stay put provision and should not apply it automatically to every student who is referred for placement in special education. But again, this is going to be one of these situations determined on a case-by-case basis. So, it was determined that possibly the student might, qualify for SPED services, but was evaluated and then did not qualify. So that's the kind of the situation that they're, that's being dealt with here. So we know now that, the 10-day limit is cumulative, it's not consecutive. Cannot be suspended for more than 10 days total during academic school year. And in those cases in which a cause for expulsion is found just, in that the cause for expulsion is not related to a student's disability, that's educational services cannot be discontinued. But again, the textbook does talk about some situations in which courts have ruled otherwise. So as with kind of all of these examples, all of these situations, courts seem to arrive at opinions that fall on both sides of the spectrum, which is the case with almost all law if you've studied law at all. It's essentially the sign of a good lawyer who can find the loophole or the ambiguity in the language of regulation and kind of work around it. So now looking at the 97 and 2004 IDEA amendments. So everything that we just looked at was kind of a build-up to kind of discipline being formally acknowledged and included in IDEA. And so we'll look at these amendments, the amendments that were implemented starting in 97 and refined in 2004. Before we do so, are there any questions before we move forward? Okay. So IDEA certainly outlines the authority and obligations of school officials in disciplining students with disabilities with more guidance than in the past. Now it's kind of explicitly laid out in IDEA. What are the appropriate kind of channels for disciplining a student with a disability than it was prior to 97. There is a clause in the 2004 amendments that gives, educational personnel some flexibility. Given that, disciplinary infractions are going to always be presenting school officials with unique situations. So there is this provision of a case-by-case determination. It can't just be, there can't just be one blanket rule that's going to cover every instance of a disciplinary infraction. These things certainly need to be considered on a case-by-case basis because they involve unique, student factors and unique, school and home environmental factors, which always must be taken into consideration. So a big one was suspensions and placements in interim alternative educational settings. Again, I'm not going to spend any more time here. 10 school day suspension is max. Educators can implement such measures only to the extent that they use similar punishments when disciplining students who do not have disabilities. So there should not be any kind of evidence that, a student who has EBD, for example, to use a disability category in which students are, quite frequently suspended. There may be a pattern of students like with this disability being suspended more often than their peers who don't have disabilities for similar, forms of misconduct. So basically, there can't be any kind of, bias, so to speak. In specified circumstances, which we'll talk about in a few minutes, students can be removed from their then current placements and put into an interim alternative educational setting. For example, a more restrictive educational setting for up to 45 days. Without regard for whether their misbehaviors are manifestations of their disabilities. Does anyone remember, well, what are those situations in which this can occur? The textbook talks about 2 of them. Situations in which it doesn't matter whether or not the behavior was a manifestation of the disability, these students can just be removed for 45 days while decisions are negotiated.
If they bring drugs or weapons.
Exactly, drugs, weapons.
Or if they're like
Certain
causing
threats.
bodily harm to.
Exactly.
Yeah.
These are serious situations in which, you know, either the student or that student's peers are being put in danger, or their safety is being put in jeopardy.
What was interesting was but pocket knives weren't included.
Yeah, small pocket knife is not included.
Yeah, it's kind of interesting.
Yeah, that's it's interesting you bring that up, because I was reading that, and when I taught at a community college in a program for students who were in special education in high school. It was a Tools for Transition and Work program. And one student did bring a little Swiss Army knife to school, and like he took it out and like showed it to one of his peers, and his peer came right away and told me, and so we had to kind of get all of kind of the bigwigs in the community college district involved, and he was not suspended. And it's different in the post-secondary setting than it is in the secondary school setting. But yeah, a pocket knife is okay, which I guess doesn't seem totally safe, especially if you do have a student who is threatening violence. I mean, one could certainly still, impart bodily harm with a pocket knife. So even though it does say it makes that exception, I would imagine that it would still be taken on a case-by-case basis,
And it doesn't specify size of the pocket knife. So yeah, I don't know. It was interesting.
Were we to dig into the details of IDEA, we would find some information about the size.
Oh, just not in the book.
It's not the textbook.
I think the pocket knife thing is funny because, like, at our schools up here where we're rural, we have kids bring pocket knives accidentally all the time because they're cutting bales, they're feeding cows, they're doing these things. So to me, like, a pocket knife would not be that big a deal, especially, unless they're wielding it and saying they're going to kill somebody with it and they've got the kid up against the wall and it's at their neck or something.
But merely observing the presence of a pocket knife is not going to be like a huge red flag.
Right, I totally get that, yeah.
Where I grew up, like, people would have shotguns in the gun racks of their trucks in the parking lot. I also grew up in a very rural community in northeastern California. So yeah, it's certainly kind of contextually informed, I would think. But yeah, that is interesting. Another interesting wrinkle presented by the rural setting.
I don't think anyone should be suspended with having it on them, but I think it should specify more like case by case.
Right. If a student has expressed the intent to hurt somebody, and then this, pocket knife is found on that student, well, I think that's a completely different situation.
Yeah.
So, it already alluded to this fact, in the sense that his team, after about 5 days of suspension, that they kind of start thinking about, well, what are some steps that we might be able to take in order to, kind of help this student remain in this placement, because we're starting to see this pattern of misconduct that is resulting in suspension. And so the IDEA does actually mandate that in the context or during these short-term suspensions that, teachers or other qualified, educational service providers must conduct FBAs of students if they have not already been completed, or if they're just old. Later in the chapter, the book mentions that the outcomes of evaluations, if they're being used in the context of a manifestation determination meeting, If they're over a year old, well, then chances are they should probably be updated, and you know, the assessments or the evaluation should be re-administered. If they're going to be used as pieces of evidence in a manifestation determination hearing, or in this case, you know, if the FBA and the BIP are outdated, of course they need to be updated. Perhaps, you know, these outdated plans are the reasons, or you know, is the reason this outdated protocol is the reason the student is you know, engaging in this misbehavior. And I mean, obviously, you know, these FBAs are intended to address the misconduct of students so that it does not reoccur. So the FBA should be targeting, you know, the problematic behavior or the behaviors, determining what is the function of the behavior, what are the, you know, what are the consequences of the behavior, what role is the, or what function is behavior serving, and, you know, how can we start thinking about, you know, shifting this, or shaping the student's behavior to be more functional. You know, we're all familiar with the fact that a suspension greater than 10 days is considered a change of placement in IDEA's eyes. And evaluating whether or not changes in placement have occurred, must consider a number of factors: the length of the removal from the placement, the total amount of time that students are removed, proximity of the exclusions to one another.
Can I ask a question of something that happened last year? So when I was in normal, I shouldn't say normal, when I was in regular ed, 6th grade teaching, in the 5th grade classroom, we had a boy that came from a school district that's just 7 miles away. And on an IEP, they had met with parents. Basically, that school sent him to us to see, or the parents chose to bring him to us to see if we could make a difference, even though in the school district, like I said, 7 miles up the road, he wasn't able to make it. So when he came into the 5th grade classroom, the behaviors obviously didn't change because home life didn't change. Mm-hmm. And if we ended up at the end of the year sending him back to that school district because he's not in our district, so we didn't have to claim ownership. But if, let's just pretend for a second that we didn't have that option. If our special ed teacher in Enterprise was very much on top of it, and she did an excellent job. She didn't let the school suspend him for more than 10 days. But he did come in with explicit language, and then he was threatening students, violent in the classroom. But what I'm curious about is, if we hadn't been able to send him back to the other school district, how, again, do we rural schools handle this? Because I'm just thinking, eventually I'm probably going to get a student that has behavioral, their IEP, it's written in their IEP. How do we, if the closest facility to help them is in Pendleton or LeGrand, 2 hours away, how do we deal with those students? I'm really curious about that.
I mean, if it's unrealistic that student be bused, you know, 4 hours every day to and from a more appropriate program,
right,
I would think that the student would have to remain in the district, and there would need to be some kind of effort taken on part of the district to bring in like a behavioral specialist. I don't know if you have a behavioral specialist on staff, or somebody who has some expertise in dealing with the kinds of, you know.
That person was brought in last year, and that happened, but the behaviors never changed. So yeah, I was just, so then would you, in our small school, put that the best that you can, provide a room where they're still getting education? You'd have to provide a one-on-one aid. Is that what you'd have to do? Yeah,
I mean, maybe that's what it would take. Is like not a program per se developed for the student, but a learning environment created at the school for the students, in which the student could, you know, make some academic progress.
Behavior plan and intervention.
Yeah.
Big time.
I would imagine that, you know, that would be temporary. Like once kind of the behaviors got under control, well, then the student should now be kind of moving back into the mainstream classroom, you know, a little bit each day. But yeah, you know, Or maybe if the behaviors became so severe, maybe there's a residential program somewhere, like in, I don't know, Boise or somewhere in Idaho, like somewhere, or somewhere even in the state of Oregon, that would meet the students', educational needs more appropriately, and that wouldn't require this, like, a 2-hour commute each way to a more appropriate school. I mean, you have to think about the continuum of services and what would be, what are all the different options at the district's disposal. And then, really the least restrictive one would be the best decision in that situation. So these regulations also add that if a student is suspended for misbehavior that is very similar to previous instances of misbehavior that was determined to be a manifestation of their disabilities, well, changes in placements will have been considered to have occurred if a student is suspended for beyond this 10-day period. But interestingly, suspensions for separate but dissimilar acts of misconduct may exceed 10 cumulative days in one school year, which I found interesting. The book didn't really elaborate much on that statement because it seems to, speak in opposition to what the chapter, repeatedly, kind of drives home. That's this fact that 10 days of suspension cumulative cannot be, gone past for a student with disabilities. So unless a student in regular education is receiving educational services when she or he is suspended for 10 cumulative days, well, school board officials are not required to continue SPED services for students who have disabilities. So this is just saying that we do not make any exceptions for students in special education when we're talking about these brief suspensions. We're not making any exceptions that we wouldn't make for students in general education. Unless the district did provide some kind of homeschooling for students in regular education, in which case those services would also need to be provided for these student with a disability. If for some reason, if in this situation in which dissimilar acts of misconduct lead to a number of days of suspension greater than 10, IDEA requires that services must begin after the 10th day. Now talking about these transfers to other settings for disciplinary reasons. Again, we've already mentioned that school officials can act unilaterally when placing students with disabilities in interim alternative educational settings for up to 45 days at a time for weapons and known drug violations. So in these situations, parents do not need to, provide consent. A school district can place a student in one of these settings just unilaterally. Of course, a decision must be made as to what is going to be this interim alternative setting for a student in the situation. But again, well, the IA team must decide what is going to be the most appropriate setting. The school district can just say, this kid's got to go. And now it's up to the IEP team to determine what is going to be the most appropriate alternative setting for this student. And again, in one of these situations, school officials must conduct FBAs and implement BIPs for students who are placed in these programs. And if parents disagree or request hearings, students must remain in these placements until during the outcome of the hearings or until the expiration of the 45-day period. So if a conclusion is reached in 15 days and this is determined that the student should go back to their, previous placement, well, then the student will go back to that placement. If, the outcome is reached in 10 days and it is determined that the student should, would benefit from the 45-day period at this interim alternative placement, well, then that's what the student will do. And again, after the expiration of this 45 days, the student is entitled to return to their former placements, even if in that situation where a court has yet to reach a decision. So if after 45 days, it is still unclear about what is going to be the best placement for the student, well, that student is going back to her or his previous placement until the school board proposal is determined. So again, regarding weapons and alcohol and drugs, a student carries a weapon to a school or on a school premises, or is at a school function, sponsored by a school, knowingly is in possession of illegal drugs or sells or solicits the sale of a controlled substance, or has inflicted serious bodily injury upon another person while at school, on a school premises or at a school function. And IDEA provides a definition for what is an example of a dangerous weapon: instruments, devices, materials, and substances capable of inflicting harm in addition to firearms, but not small pocket knives. That's brought up. Illegal drugs include controlled substances, but interestingly excludes controlled substances that may be legally prescribed by physicians. So that got me wondering, if a student, for example, with ADHD is selling his Adderall to her peers, would that student not be subject to this 45-day period of an interim alternative placement? But the book didn't mention anything about that, and I did not get the opportunity to do any research.
Yeah, it makes me wonder if they're just carrying it in their pocket, which they shouldn't be. If that could,
What I meant? Yeah.
they could think that they might be selling it or giving it away, or I don't know.
The student is caught actively, selling it. I would imagine that, that this caveat here wouldn't apply. That the student would, in that situation, be considered, selling, illegal drugs. And then lastly, IDEA gives us some definitions of serious bodily harm and how that's different than, just bodily injury. And then there are other, infractions that IDEA also permits moving students to alternative placements for, which aren't specifically listed in its provisions. One example was the textbook described the case in which a student pantsed one of his female peers. There are other instances in which students were using sexually explicit language directed toward their female peers. These aren't, explicitly articulated in the same way as are these situations of bodily injury, and, drugs and alcohol. But anyway, we have reached our 7 o'clock ending time. So I'm going to stop there. I'll put these slides up on Canvas right now before I leave the office. So if you want to have a look at them, they'll be there. And then I'll put this video on Google Drive and also on YouTube. And so I forgot to mention, we had a very brief discussion about difficulties accessing some of the files of the lecture recordings in the Google Drive folder that I created. So what I went ahead and did was to send around a link to my YouTube channel, which has on which you'll also be able to access the recordings. So if you can't get them in the Google Drive, just use that link that I sent around. But before we go, are there any questions or closing thoughts or anything?
Nope.
Okay, then well, I will see you all tomorrow, and we will have a nice discussion about autism spectrum disorder. So have a good night, guys and gals.
Thank you.
Thank you.